United States of America is the greatest country in the history of the world. There's no question that our country has done more to advance the cause of liberty and democracy than any other nation ever. As our Constitution says in its preamble, we're always striving for a more perfect union. Yes, our country has not always been perfect, and we must acknowledge and learn from our failures. The Democrats would have you believe that we are facing some sort of crisis that requires radically changing how we run our nation's elections, but the facts just don't support their arguments, as I hope we will hear today. This is the subcommittee's sixth hearing on H.R. 4, a bill that the Democrats have yet to reintroduce in this Congress. And even though this bill hasn't been introduced, the majority leader announced that the House may vote on it as early as next week. So this is likely the last time the committee will have a chance to talk about the legislation, and we don't even know what's actually in the bill. In 1965, Congress passed the Voting Rights Act to overcome state resistance and barriers that prevented some minorities from exercising their right to vote guaranteed by the 15th Amendment. As originally passed by Congress, the VRA included extraordinary departure from the principles of federalism to combat the, quote, exceptional conditions during a dark time in our nation's history. Despite what some Democrats say, the United States has come a long way since then. In 2013, in Shelby County versus Holder, the Supreme Court struck down the VRA's coverage formula as was outdated. The exceptional conditions from 1965 no longer existed to justify subjecting states to pre-clearance approval from the federal government, as the ranking member of the subcommittee said earlier. The court's decision in Shelby acknowledged the progress that this nation has made since the 1960s, and thankfully, America today is not the same as America was in the 1960s. We should all applaud this progress. Despite the strides our great country has taken, Democrats like to claim that the Supreme Court has gutted the VRA, and they say that's why it's urgent to pass H.R. 4, but the facts just don't back that up. What the Democrats fail to acknowledge is that the court's decision in Shelby County did not strike down all of the VRA, not even close. Section 2 and Section 3C remain effective tools to root out intentional discrimination where it might exist. H.R. 4 isn't legislation designed to fix Shelby County. It's legislation designed to radically change how we run elections and to politicize enforcement of the Voting Rights Act. There's no need to amend the VRA and devise certain provisions such as this Section 4B coverage formula that unconstitutionally and unjustifiably encroach on state sovereignty. Also, in another brazen attempt to grab power from state control and give it to partisan bureaucrats in Washington, H.R. 4 seeks to institute a practice-based pre-clearance provision. This provision would not just apply to states with histories of illegal discrimination, it would apply to every state and political subdivision in the entire country. In other words, every local county or city would have to get approval from unelected people in the Justice Department before changing its election process. That's some scary stuff. This provision is also designed to target popular voting integrity measures like voter ID laws, which polling shows most Americans strongly support. Americans deserve free, fair, and accurate elections. Every legal vote should count, something these voter integrity measures would help to ensure. But to justify the unconstitutional federal overreach of the H.R. 4, Democrats argue that states have enacted allegedly suppressive voting laws. The Democrats ignore one glaring fact, however. It is easier today for eligible Americans to vote than ever before in our nation's history. And it's interesting that Democrats always target Republican-led states like Georgia and Texas for allegedly suppressing the vote when these states actually have more expansive election procedures than Democrat-run states. Georgia, for example, has 17 days for early voting. President Biden's home state of Delaware only has 10. Georgia has no excuse absentee voting. Delaware requires an excuse for absentee voting. But you don't hear Democrats complaining about Delaware. And you don't see the Biden administration bringing suit against Delaware in federal court. The Biden administration's Justice Department has unfortunately politicized enforcement of the Voting Rights Act. And to see how, look no further than the guidance issued by Attorney General Garland last month. In 2020, many states adopted temporary voting procedures to reduce public health risks during a once-in-a-lifetime pandemic. Recognizing the temporary nature of these voting procedures, in 2020, Attorney General William Barr directed the Civil Rights Division to adopt a VRA enforcement policy that would, quote, presume it lawful for a state to revert to election laws or procedures it had before the pandemic. On February 3rd, 2021, the Biden administration abruptly rescinded Attorney General Barr's guidance, and on July 28th, Attorney General Garland issued new guidance. The new guidance said that the state election laws and procedures that existed prior to the pandemic may not be presumptively lawful. So if a state had a lawful election procedure prior to the pandemic, then changed it to something else, and now wants to change it back. The Biden DOJ said it can't do that. With this new guidance, this department takes the position that the temporary emergency measures implemented during the pandemic are the new baseline from which to judge compliance with the Voting Rights Act, contrary to Congress's intention in passing the legislation. Congressman Johnson and I sent a letter to Attorney General Garland last Thursday, strongly urging him to rescind this guidance. We hope we will get a full response from the Attorney General before the House votes on H.R. 4. Even more dangerous, H.R. 4 expands the role of the Justice Department in election administration. As Attorney General Garland's actions have shown, the Biden administration intends to politicize enforcement of the Voting Rights Act. We cannot trust them with these new authorities. Our Constitution, the backbone of our country, is clear that states have the primary authority to administer elections, even federal elections. H.R. 4, along with the Biden's DOJ's politicized enforcement of the Voting Rights Act, is a radical effort to federalize elections. It's not supported by the law. It's not supported by the facts. It's a power grab, pure and simple. Mr. Chairman, thank you. I yield back.